Just as one learns a new language when one goes into a new country, we must learn the language of equality in the hope and with the desire to eliminate injustice. She did not say equality would come easily. She said it must be learned, deliberately, consciously, and with desire. Yet, here we are, decades since she broke that first barrier, still in the early chapters of that lesson, still conjugating the same verbs, still stumbling over the same sentences. Today, through this panel discussion on breaking barriers, challenges faced by women in the legal profession and the way forward, the Wednesday Club is long overdue in every bar and every court. Not whether women belong here, they do, but what still stands in the way and what we owe each other in removing it. We are fortunate to have with us Honorable Dr. Justice A.K. Jayasankaran Nambiar, who will moderate this conversation with the wisdom this subject deserves. Alongside him, Honorable Justice V.G. Arun, former Judge, High Court of Kerala, Advocate Parvathi Menon and Advocate Surya Binoy, voices that bring both the views from the bench and the reality of the bar. To formally welcome our distinguished guest and set the stage for this important conversation, I now invite Advocate Vinay, Vice President of the Kerala High Court Advocates Association, to deliver the welcome address.
A very warm good evening to all of you. Honorable Dr. Justice A.K. Parvathi Menon, Madam, Advocate Surya Binoy, Honorable Judges of this Court, Honorable Justice Mohammed Niaz sir, Senior Advocates, Balaji sir, and esteemed members of the association, as well as the young and jubilant members of the Wednesday Club. Today, it is not my prerogative to formal elongated welcome speech, because every minute is precious. We have a very vibrant discussion online, and as we all know, Honorable Dr. Justice A.K. Jayasankaran Nambiar sir has kindly consented to be the moderator of this very interesting and debatable discussion on the various struggles faced by the women in legal profession. Equally, what are the ways forward also? I, on behalf of the Kerala High Court Advocate Association and the members of the Continuing Legal Education Club and Wednesday Club, I wholeheartedly welcome Dr. Justice A.K. Jayasankaran Nambiar sir to this discussion. We all know we deeply and greatly miss Justice V.G. Arun sir, and every opportunity that we get to hear him is really a moment of pleasure and surprise. And His Lordship, even when we approach, His Lordship is now officiating as the Chairman of the High Power Commission for the Bar Council election in Kerala. Even in the midst of all these important things, His Lordship has very much consented to be a panelist and actively participate in this discussion. I, on behalf of the Kerala High Court Advocate Association and the Wednesday Club, wholeheartedly welcome Justice V.G. Arun sir to this discussion. For us, in every legal discussion, Advocate Parvathi Menon is an unavoidable member. When it comes to the legal problems and the challenges faced by women lawyers, we cannot get any other brilliant speaker and a panelist to present the topic. I, on behalf of the Kerala High Court Association and Wednesday Club, wholeheartedly welcome Advocate Parvathi Menon, Madam, to this discussion. And our own young and energetic Advocate Surya Binoy, who is presently the government leader as well, and she has always been fighting for the cause of women, orating for the cause of women, and has been consistently a patron of rights of women activists across the state also. And we are really glad to have her also as one of the panelists. I, on behalf of the Kerala High Court Association and the Wednesday Club, graciously welcome Advocate Surya Binoy also to the discussion. We have with us Honorable Judges, Justice Mohammed Niaz also in this event. I wholeheartedly welcome Mohammed Niaz sir and every senior advocates and every member of the Kerala High Court Association as well as the Wednesday Club to this gracious moment, and we are starting off the Wednesday Club with this event. And just I will give you a brief of what we are intending to, the association is intending to do with the Wednesday Club. Just a short glimpse. Today we are starting with a legal discussion on the panel discussion. We have in our mind, and we are planning to execute other various legal programs, including legal debates, case law, prominent case laws discussions, critically analyzing case laws, where we are concentrating on participating the young lawyers so that they also get an opportunity to be part of discussions, not as simple speeches alone, but an interactive session so that the young generation of lawyers can grow with this club. That is the prime objective of this Wednesday Club. So we also are planning to bring in interdisciplinary experts like forensic experts, cybercrime experts, and even the latest technology we know, that is the AI experts. We are also planning to bring them also. We are also planning to conduct debates on the shortfalls of the present laws that we are having. We want this group to come up with all those suggestions and recommendations that can be placed before appropriate authorities or commissions if needed, so that this group will function as a very productive team of lawyers who can contribute to the welfare of the new statutory regimes, also the prevailing ones. And we also plan to conduct monthly lectures in the sense interactive lectures, by bringing in legal luminaries from across the country as well as jurists, so that we can have their experiences on various topics of law also. Then we also want to have bench and bar interactions. That is what we are prominently considering, so that we can have an interaction with the honorable judges and the problems faced by them from the lawyers as well as the other side, so that we can have a general discussions on the case filing system, the code of conduct, and the judicial decorum that has to be kept. All these matters can be discussed on these interactions also. We will be having law reform working groups, I already explained, and annual workshops also we will be having. By the end of this year, we are planning to have a huge annual workshop also conducted by this Wednesday Club. These are the things in our mind, and we also expect cooperation from the bar as well as the bench, because the honorable judges of this court as well as the senior advocates are the guiding forces behind every continuing legal education program of association. I welcome all of you again to this panel discussion. Thank you so much.
Thank you, sir. Before I hand over to our moderator, a brief note for everyone in the hall. As stated already, the topic for today's discussion is breaking barriers, challenges faced by women in the legal profession and the way forward, which shall be analyzed today in a three-pronged manner under three different sub-themes. Theme 1 shall be professional challenges faced by women in legal profession. Theme 2 shall be legal and institutional framework affecting women in legal profession. And the last theme, Theme 3, shall analyze the way forward, reforms and practical measures. This shall be dealt with by each speaker in this panel. In addition to this, in the interest of a focused and uninterrupted discussion, questions to the panelists will not be taken from the floor at the time of the discussion. Instead, we have a simple way for you to raise questions. On your seat, you will find a QR code, a printed version of a QR code. Kindly open your phones, point it at the code, and a link will appear on your screen. Tap on it and it will take you directly to a WhatsApp group created for this discussion. Once you join, simply type your questions and send it in. When sending your questions, kindly mention the name of the panelist it is addressed, so the moderator knows who you would like to hear from. The moderator shall be taking up the questions at an appropriate time. With that, it is my privilege to hand over this discussion to our moderator, Honorable Dr. Justice A.K. Jayasankaran Nambiar, who will handle this conversation with the wisdom the subject deserves. Your Lordship, the floor is all yours.
Am I audible?
Yes, sir.
Good afternoon to all of you. First of all, congratulations to the High Court Advocate Association for this wonderful initiative, the Wednesday Club. which is basically floated for the purposes of fostering a discussion and deliberation on various aspects of law. It just so happens that they commenced their activities in the month of March, which coincides with the month of Women's Day celebration. But I think it's always a auspicious start when you start discussing women's problems and trying to find solutions. Having said that, I would have preferred to see a lot more of men in this room, because any discussions on gender equality, gender sensitivity begins with education of the problems faced by women among men, the male counterparts. But I do see a few men in the room, and I think it is worth applauding them for being here today. So can we hear it out for the moment? Thank you. The subject is nothing new. We are talking about challenges faced by women in the legal profession and the way forward. Challenges faced by women are not confined to the legal profession. Women have faced disadvantages throughout history when it comes to their status in society. The technological advancements over the last 50, 60 years have enabled us to understand or get a better understanding of the reason why that discrimination or the disadvantage arose. It is primarily because of the data bias that informed our knowledge accumulation process. Right from prehistoric times, you find that there is a particular narrative about how societies evolved and the role played by men and women in those societies. And we realize now that most of those narratives were wrong, incorrect. And one suspects that it is incorrect because it was actually advancing a particular perspective, which sadly was a narrative of the male of the species. So over the years, you find that there has been a dominant view, and that dominant view has been against the female of the species. And that dominant view, because it had the effect of empowering the male of the species, was preserved. The status quo was preserved throughout various stages in history. When you read a lot about this historical perspectives, you find that there have been many occasions or many periods in history where women were actually at one point dominating in society generally when it comes to trade, when it comes to holding positions of power. But those periods are very short-lived, because somehow or the other you would find the male of the species dominating in society and taking back the power. But it is only in recent times, the last maybe 6 or 7 decades, that we have knowledge, reliable knowledge, scientific knowledge, which shows beyond doubt that the female of the species was actually better suited, and what we thought was actually a domination by the male was not actually a domination by the male, it was by the female. And that can't be controverted. So newer knowledge has given rise to a inspiration or given rise to movements, feminist movements, which you've seen over the last 6 decades. The feminist movement has actually got a thrust or a boost through that newfound knowledge. And that is why we see advancements in the social status of women in the last 5 to 6 decades. But we still find them falling short of the desired level. Why that is so? What are the contributing factors? And is there a way forward, and how? These are what we are here to discuss today and to do that, we have eminent panelists. We have, first and foremost, Justice V.G. Arun, former judge of the High Court of Kerala. I hate to call him that, but I think he looks a bit more cheerful than he did. I'm dying. I was asking him questions and I told him that I'm dying to be there myself. Of course, he needs no introduction to this crowd. His views generally about most of the issues in law have been sober, very erudite, does a lot of reading. There's a lot of information that comes through his judgments and his opinions. So I'm actually looking forward to hearing from all the speakers, including him, today. And he will be talking about the legal and institutional framework affecting women in the profession, if I'm right, mainly on that. We also have Advocate Parvathi Menon. Again, I mean, none of these panelists need introduction to you. She's going to be talking about the professional challenges faced by women in the legal profession. She'll set the tone for the initial discussion. And Surya Binoy, she will talk about the future, the way forward. So with that brief introduction, let's set the ball rolling. Can we start with you, Parvati, on the topic of professional challenges faced by women? Just give us an idea about what, according to you, are the challenges faced. You can start.
Good evening, honorable dignitaries on and off the dais, my dear friends. It's a great privilege to be here, especially to talk on this subject. I was under the impression that I could speak from my heart till yesterday when I was told by the organizers that I have a research team to come and brief me. So when I went through the concept note that they shared with me, I realized that they have done a very extensive research as to how things have been throughout, and also they also supplemented a few Supreme Court decisions as well to point out the particular point which to focus on the point which we are expected to place before this August audience. Anyways, before going into all those aspects, into all the research work or whatever it is, let me start from where Honorable Justice Nambiar stopped. That is regarding the perspective, a narrative which had dominated in the society for long regarding the women's role in general. For that matter, I think I too belong to a patriarchal society where I have also been conditioned to a lot of language, to a lot of thought process, which I was forced to, or rather constrained to take a U-turn and think otherwise when my children grew up. This is something which I think I had shared with the researchers who spoke to me yesterday also. So there are many aspects which are ingrained in us which we do not actually realize, at least people of my generation. We generally speak of giving girls in marriage. How do you give a girl in marriage? And she's not a chattel. So these are all language, these are all words, these are all vocabulary which we use unconsciously. Why do you ask a boy, why, as though like boys cannot cry? Or when at some point, if you remember, I mean, like if you recollect, during our times, when you go for a birthday party, if it's a boy, you buy a gun or some kind of toys like that, a doctor's set or something like that. When it comes to girls, you immediately tend to buy a kitchen set. So these are all things which are conditioned, which are ingrained in us. So these are all things which we will have to unlearn or start rethinking when we start thinking about the problems that as women in the profession what we are facing. So from there, let us see how things are when it comes to law schools. Let's start from the law schools. Law schools, of course, we know like it's quite gender neutral that way. I think almost all the law colleges and law schools, we have gender neutral attitude, we have gender neutral policies. We have, like it's very different nowadays from what we have studied. But then towards the end, we need a finishing school which should bridge the gap between the actual learning, the actual academics, and the professional skills which we need on a gender neutral term. And then once the women, for that matter, I would prefer to talk on a gender neutral term, especially by using the term persons. But of course, women have their challenges on a different, in a different version also. So once they come to the profession, at the entry stage itself, they start facing these issues from internships onwards. This is something which I have always thought of suggesting to the bar associations as well as to the bar councils, not that I'm jumping onto conclusions or the ways forward. We can have structured internships in which there could be situations where towards the end, the last lap of the education, the last year, the last lap, 3 months or 2 months or whenever they go for the internship, they can be absorbed by the firms in which they have been interning, or the offices chambers in which they have been interning. Because generally, it's the entry point. What we find is once immediately before they get themselves enrolled, you find a rush of a lot of prospective lawyers running around in search of offices. That's a major issue that is the point where women get eliminated. Because immediately what they say is, what the tendency is to say that women, okay, now they might not be able to sit late at night, or we do not know how far they will be good in the offices, how far they'll be able to sit through, how far they'll be able to do client dealing. These are all professional capital issues which we will have to deal at the second stage. Now the entry level itself, they are filtered. So this is something which I'm sure which the institution can take over, because what I would like to say in a whole is, instead of considering this as a personal resilience, like an individual resilience, somebody would have been able to get over all these issues and be prominent in the profession. A woman would have been able to. There are women who have been able to. But more than that, what we need is a structural evolution. It's a structural evolution on the side of the bar associations, bar council, the bench, the institution as a whole. That is the outlook towards women, that how you accept women in a gender neutral. Don't show them gratis, and don't glorify their achievements. We studied the same law. We are practicing the same things. So instead of don't show the gratis, instead of glorifying the achievements, it should be the order of the day. Why can't a woman also do the same thing? Oh, she has done it. Why should it be a news at all? So that should be the order of the day, or that should be our vision in which we should do. So entry point, it could be like that's one stage where we find a lot more difficult. The taking up otherwise normally what happens is, women lawyers, once they enroll, they try to get into informal chambers, or like where they have connections through families, or something like a senior junior patronage, where you are given a space in the chambers because of that. Instead of that, if there is something like a connect or something like an institutional structuring in such a way that once at the internship stage itself, if the bar council along with the law schools can have tie-ups with many firms, the last lap of the internship can be used to assess them independently, irrespective of their gender, assess them and then absorb them into the chambers. That could be a very good alternative for the present chamber hunting for the lawyers in general. So that is one area where the women lose a lot of space. Then, of course, we have retention issues are major. Once you come to the profession, what we find is there it's not just the competence. Lots of lawyers, they are very, very highly competent. Because right now I'm actually very happy to see each, and that's something which I have to appreciate the present High Court Association. each time they host a program, I find a new face coming up on the stage as an anchor. So it means a lot of opportunities, be it boys or be it girls, a lot of opportunities that are being given to girls in general. I think girls, I've been watching a lot of girls coming up as anchors. So these are all, visibility is an important thing. So more than competence, what you need is professional capital. For professional capital, what you need in the office, you need clients counseling. You need client counseling. The seniors should be able to make the junior lawyers, irrespective of their gender, sit and counsel. When the client counseling happens, I think client counseling also, when we were in law colleges, when we were, I think Honorable Justice Nambiar would also recollect, when we were in colleges, what used to actually happen was, all that we had was one moot court. But now I understand there are a lot other competitions also. There is something called client counseling competition. There is something called mediation competitions. So negotiation competitions. So the outlook has changed, the approach has changed, and there are a lot of opportunities also. So for client counseling, I'm sure the women are also well equipped. So the moment the clients also find the seniors giving ample importance to the juniors who are sitting along with them, and making them elicit facts or whatever details from the clients, it will make a huge difference. From tomorrow onwards, I have my juniors. I've got 3 of my girl juniors. I don't know whether they have come. They had threatened me to come here and ask me questions, but I think I didn't find them here. Anyway, most of them sit along with us when a client comes. So what happens is, in the next to next sessions, the clients normally contact these lawyers in order to find out the progress of the case, whether the case has been filed, what has happened to the case, what is the next petition that has to be filed in the case. So this is something very, very, I'm sure it gives them a lot of confidence. It gives the clients also a lot of confidence when the lawyers are being introduced, the junior lawyers are being introduced by the seniors themselves. So that is one area of client counseling where the women lawyers can very well equip themselves. Then, of course, you have visibility. Visibility is a major issue. As you say, like all cases, we might not be able to, all the seniors might not be able to let the juniors argue the cases. But of course, by default, at some point of time, when the seniors are not able to reach, but make sure that all your juniors study the briefs and go, so that even in your absence, that they take up the matter. Because I know as a junior, I have been multiple times I have been told by the benches that make sure that you come and argue the next time itself. If your senior comes and argues, that case is gone. But recently I have been hearing judges also, the present benches also stating the same thing. You argue the matter, you come the next day also, you come prepared. Don't let your senior come. The senior might not get the same kind of consideration that you might get. So these are all things which the bench, the institution can do for the women lawyers in particular. Because retention, again, visibility is a major issue. Again, it's something which, since we have the judges here, it's something which I wanted to suggest also. There are many cases which we have watched in criminal courts, especially when it comes to 125 matters, maintenance matters, old cases where one of the parties, though service is complete, nobody appears for them. So if the bar associations can keep a list of a digital base of domain experts, there are women lawyers who are really experts in certain fields. If you can keep a list of those domain experts, the courts can appoint them as amicus for those people who are not being represented. So the girls, the junior lawyers, they get that visibility. Once they keep arguing matters before the courts, then of course that confidence level boosts. Then of course they will also be able to get cases on their own. That is also one area which I have felt, which the institution collectively, in the sense where the bar associations, the bar council, plus the bench together can think of something like this, appointing amicus. Also, unless there is a major question of law, of course you can have a senior person. Again, a senior person need not be a senior male lawyer, it can be any person for that matter. But regarding appointment of amicus also, if women lawyers, junior women lawyers are given that opportunity, again, government panels, state briefs, these are all areas where the women lawyers can make up their visibility. And then of course, the next stage, once that retention stage, then of course, as far as the women are concerned, there is one stage of when they take to maternity or when they take to marriage, matrimonial issues, maternity and things like that. There will be a short period when they are constrained to take a break. But then again, I think there is a change in attitude in the present generation in general. There was a time when we all essentially believed, or rather our generation or perhaps the generation immediately next to us, really believed that taking care of children are exclusively the mother's prerogative. It is the fathers are expected to go ahead with the work, the mothers are expected to take care of the children and the home. So that is the reason why we all speak about work-life balance. For that, I think there is a change in attitude generally, for which I can give you a small anecdote. What happened in my own life, about a few years back, when my son was still in standard 12, or rather 11th or 12th. My daughter was working, there was some age disparity between them. My daughter was working even then. One of the weekends when I was working in the office, my son was at home and my daughter was in Bangalore in her workplace. So when I was working at home, at office, in the office around 8:30 in the evening at night on a weekend, and then suddenly she as usual, she calls me just to find out how things are as a courtesy call. And while I was speaking to her, I get a call from my husband, who was also in the office. He just called me on the intercom just to find out, like he asked me, oh, you have also not left from office. Apu's at home, he's all alone, so why don't you take your work home and then, complete your work, so that he can also be attended to. I didn't find anything odd when he told me this. So immediately I said, yes, I too didn't realize it was already late. So I think it's time that I too leave. And this, my daughter was holding the phone, she overheard this, and immediately she cut the call, and she called my husband, and she asked him, don't you think Apu is your responsibility as well? If you felt Apu was alone, why didn't you stop your work and go home and take care of him till Amma completes her work? And once Amma completes her work, she will get back home, and then why don't you get back for your work? So at that point of time, only when she spoke about this, I started thinking, okay, now she is right. Because I never thought there was anything wrong in what my husband told me was, because I'm conditioned to it. That's the thought process which I was conditioned to for a long, because that's how my generation has been thinking. So this kind of thought process perhaps will help the present generation women lawyers also, because marriage, they should be able to see it as more like a companionship rather than it's like system of marriage. These are all things which are ingrained in us. So that thought process has changed. So once the thought process has changed, I'm sure that companionship will be there. So as far as the taking care of the family, you should be able to expect your companions or your partners also to help you. And when it comes to the profession, I think digitalization is going to help you a lot. Even after the initial days of the maternity issues, the women lawyers will be able to continue with their profession to a very large extent if things are on a hybrid mode. So that should also be to be a very helpful aspect. And one other aspect, before any question comes on that, I was thinking about it, because that's something which is normally a big question nowadays regarding the menstrual leave. Because there are many issues when many places who think that menstrual leave will cause a lot of disruption, occupational disruption, and that will the organizational disruption also. So it's very difficult to hire women. So instead of that, thinking of that, why don't you consider it as a policy? If it is considered as a policy, then you will be able to find innovative methods or safeguards to see to it that it's not misused or disruption doesn't take place. Because there are so many opportunities for work from home. You can take your work, if 1 or 2 days, if you are on leave from the chambers, you can take the work home, complete it, finish the drafting and give it back to the office. So there are methods how you can handle that also, as long as you consider that as a policy, because the inconvenience of the employer is not important. What is important is the work productivity. Work productivity in the space that you work. So these are all a shift of attitude which we are all expecting, and if that happens, of course, these are all challenges, these are all areas where women find it difficult, and I have just casually mentioned certain areas how it can be faced also. Of course, Surya might be dealing with it in in a very elaborate manner. One more aspect is when it comes to selections to the judiciary. As far as the judicial selections are concerned, when it comes to the Munsif test as well as the district judge test, we find, I think Munsif test, what I understand, is about 60% of the present trainees, 60 to 70% of the present trainees are women. They have passed the examinations. When it comes to the higher judicial level, again, the issue perhaps is visibility issue, which has to be addressed right from the beginning, as I had stated. And of course, a lot of transparency would help. Perhaps we have the collegial judge sitting along with us, so that should be more helpful also.
Walk the talk.
Yes, who walk the talk. Please, so that should also be the transparency and also visibility of women lawyers. Of course, and on the higher in the higher judiciary, the selections we find more difficult. We don't find much women judges at all. Even in Supreme Court, what we understand is after 1989, after Justice Fatima Bibi was elevated as a judge, about only 11 judges, including Justice Nagaratna, right now. That's how it is. Of course, there was a conference very recently on 8th of March on the Women's Day with a slogan, "Half Nation, Half Bench," and we are expecting wonders after that. Of course, it might take some time. This is not a utopian idea at all. This is only a shift of attitude. But as much as the societal change is expected, we need a structural evolution also, for which all of us should start thinking in such terms. Thank you.
Yeah, point taken, Parvathi. Before I go into that, you were talking at length about visibility. There's a junior of yours who's been lifting a hand. Yes, and you conveniently said that no junior of yours is here. But you're right about, see, we all know how this patriarchal mindset set in. It's partly passed down through generations. You have a particular, it's basically indoctrination when you're a young growing up mind. And there's a lot of things that are fed which you blindly accept. The question is, to what extent have we started critically analyzing or questioning those things that we've been taught? The other is, as Parvathi mentioned, there's this probably an unconscious adoption of language that is sexist, is not gender neutral. She gave the example of Kalyanathila Kodukka in Malayalam. You have a host of words in English which have those, like, what do you call a man who's weak, who's too timid, etc. You say he is effeminate, right? So words that are linked to the female are actually used in a derogatory sense, whereas words that have got a etymology which traces to the male gender are used in a good sense. You say dissemination of knowledge. When you come up with a brilliant idea, you say it's seminal. Right? The etymology of those words, it always traces to the male sex organ and the male thing. So these are not things that we notice when we use the language, and there is a lot of bias that stems in from the unconscious use of language, and that in some sense affects the mindset. When you keep using words which are not gender neutral, unknowingly you start believing in them, and then that also affects your perspective. So there is a patriarchal mindset in all of us, thanks to the way we have sort of imbibed knowledge from various sources. But how do we what exactly are we trying to dispel? Are we saying, what did we learn from all this? Did we think that men and women are equal in every respect? I don't think so. The fundamental differences between the male and the female of the species, I think everybody accepts and understands. So it's not a biological equality that we're looking at. And in fact, our constitution also talks only about equality of status and opportunity. So it's that goal that we're looking at the status of women in society and letting the women have equal opportunities as men in governance and in matters of governance. So the question that we need to ask ourselves today is, in the last 75 years or more, have we actually advanced in terms of that equality and of status and opportunity? Given that these are the factors that affected or forced the disadvantage on women in respect of status and opportunity, how much do our law schools actually address that issue? Justice Arun, if you can just touch briefly on that, and then I'll come to Surya with regard to the structural changes before Arun gets it.
Before I start, let me just tell you it's a pleasure to be back amongst my friends on the bench and my friends at the bar. Thank you very much for providing me with this opportunity. It's always a privilege to be on the dais with Dr. Justice Jayasankaran Nambiar, my dear friend, and one of the best brains, legal brains I've come across, to put it. So, Friday Club. On the question that is now posed, patriarchy, as all of you know, it is embedded so deeply in us. On the surface, we may feel that it has disappeared or it is gradually disappearing, but it is there. The ripples are still there, and for that, to get over that, we have to unlearn deeply embedded patterns in our thinking, in our behavior, in our relationships. One example which Parvathi had just spoken about, Sanjay, one of the most liberal minds which we all know, whom we all know, and even when he asked Sanjay, Parvati to go home and take care of their son, there is an element of patriarchy involved. The daughter realizes that immediately, and therefore the promise lies in the next generation, who, unlike us, has realized and has found immediate succor to patriarchy. Therefore, in law institutions also, there's a great change happening. That is what I understand personally, because my daughter has come out of a law school, and it is very difficult these days to speak to them, because they will find fault with every word you say, because it is either the color, it is either the gender, so body shaming, some sort of shame will be there, so you have to be extra cautious. So there's a gradual change happening, and it is a welcome change. That's what I have to say on this.
And before I call upon Arun to speak on his topic, Surya, just a quick word on, you see, if you're bringing about structural changes, according to me, you're basically trying to change a mindset in people. It's all right to be talking among friends and among people who you know, and expressing displeasure at certain kind of conduct or vocabulary. But if you want to make this a structural change, it needs to appeal to persons in power. So how do you see that happening in the near future? Because you'll be speaking about it at length in your section, but how do you see that happening in our society when it comes? What is the access that you have, or what is the persuasive effect you can have on persons in power who may not be sharing the same perspective as we are discussing here?
Thank you, sir.
To begin with, I'm very happy that none of us here used the term justice. Law is a jealous mistress. Of all the euphemisms that remind me of men in wigs, this is the one I hate the most. So at least we have made that much progress. But as always, men got applauded for just turning up. Having said that, I believe the question is, if there is change in the structure of power, where can that lead to? I'm tempted to use an example from the New Yorker magazine. In 1992, the former editor of Vanity Fair magazine, Tina Brown, was appointed as the editor of this highbrow urban magazine. It was a decision, a controversial decision that shocked everyone, the usual patrons of New Yorker. What she did was to fire 71 people immediately once she got on board. She also hired 50 persons, including a woman who was already 7 months into her pregnancy. So if there is, so that even to us, even to the most enlightened ones among us, that feels like a counterintuitive decision. But then she goes on to say the working mothers in that organization who are all very busy, who are all very protective, had always had each other's back. She says this was like a secret society. And she says she knew each employee's nanny's name. So I believe when there is a change in power, the way we are accustomed to, the way we are accustomed to view things as, that changes, that will change. It is why I always request Shalina Chechi, the IST, to always come forth and take the front chair. Because you symbolize something that we are not used to. This shouldn't be an unusual sight. We all should be getting used to the sight that women are in power. Like Parvathi Ma'am said, it should not any longer make any news. When Sandra O'Connor was appointed as the first woman judge of the Supreme Court of the US, she said, I am glad to be the first, I am hoping this won't be the last. So that is where all our attempts must lead to. We are all happy about the first, but that shouldn't end there. Now specifically to answer the question, from a woman that is holding power or people who are trying to break the hierarchy, even though they may not share the views. I believe even my best friends may not agree with me on the ways to tackle sexual discrimination. On every point, on every lived reality, we will all have different views. Some may think that gender neutral laws should be our aim. Some may think the time has not come. Some may think our society is not yet ripe. But some battles and some arguments are fought and urged so that we can fail. We do not need to win every case. We do not need to win every legislative battle. Some are meant to fail, but these are the stepping stones for failure. So I believe even if the ones who are in power do not take up the causes that we believe should be their priority, but yet there is hope. There is hope for a channel of communication. I'm hoping you will be cutting me short as you are used to.
I think sometimes you can have self-regulation.
Point taken.
Am I taking that you finished?
On this question, yes.
Okay. Over to you, Justice Arun. Justice Arun is going to be telling us a little bit about illegal and institutional framework affecting women in the profession.
Before going to the topic, the topic of discussion today is breaking the barrier. I have a feeling that we should be getting over the obstacles because barriers, to a large extent, I started here in 1989, and over the past 35 years, I've seen how the young women have become more confident, bold. The way you stand shoulder to shoulder and you're able to fight out your cases sometimes better than the men. So I think many a barrier has been broken, and it's the obstacles that remain, and those obstacles are not unsurmountable. They are obstacles which can be gotten over. So, on the question of patriarchy, just as Jayasankaran was saying, 75 years down the line. So, I start with a small excerpt of a speech by Jawaharlal Nehru in 1951. This is in the Parliament in 1951. This is what he said. We are not merely technically the inheritors of the fathers of the Constitution. We really shaped and hammered it after years of close debate. So, focus is on the fathers of the Constitution. Are there not mothers of the Constitution? Why the fathers of the Constitution alone? See, 299 members in the Constituent Assembly after 1947, 15 women, 2 from Kerala, 3 from Kerala, including Ammu Swaminathan, Annie Musteen and Dakshayani Velayathan. And we do not know, because I recently came across a book titled, a recent book by a scholar, Founding Mothers of the Indian Republic. A good read. You should definitely read. And the amount of contribution these 15 women had made in the debates of the Constituent Assembly, somehow it is erased. It is not forthcoming. That is where the patriarchy lies, from persons whom we consider leaders, whom we consider so liberal. So this is a short excerpt of a speech by none other than Jawaharlal Nehru, who says, founding fathers of the Constitution. So the tremendous amount of contribution that the women have made to this country, right from the Constituent Assembly onwards, that has not been recognized. But over the years, I find that the women of this country have found their voice, and their voice are being heard in the halls of the Parliament. Their voice are being heard in the annals of the courts. And my experience as a judge, I found that many among you are at par or above many of the men. Don't feel bad, but you have reached that stage where you can think of crossing the obstacles rather than breaking the barrier. And if the barrier is to be broken, it does not merely depend on numbers, because if 15 women in a 299 member Constituent Assembly consisting of stalwarts, right from Dr. Ambedkar onwards, could make a change in drafting the Constitution, then it does not merely depend on numbers. Having said that, I'll also say that there has been a change by the Supreme Court requiring the minimum number of women members in the bar councils, state bar councils. So the numbers are there now. After these elections, the numbers will be there, and it is now upon the women members to insist for changes, because I find that the bar council rules completely lack when it comes to gender equality, when it comes to a safe place for women to practice. Now, I came across a rules framed by the High Court recently. It is for the High Court alone. It came out yesterday, I believe. Yes. A welcome change. Some of you may not have come across this. The regulations of the gender sensitization and sexual harassment of women at the High Court of Kerala, Prevention, Prohibition and Redressal Regulations 2026. A welcome change where provision is made for a committee for making a complaint to a committee. The committee conducts an inquiry, places its report before the Chief Justice. The Chief Justice in turn hears the person who lodges the complaint and the respondent against whom the complaint is made, and comes out with a punishment. The punishments, it's a bit vague when it comes to the punishments, but there also it is lacking for, it is only with respect to sexual harassment within the precincts of the High Court. Now, as far as lady lawyers are concerned, most of the time are spent in the offices within closed spaces, and if law is lacking to provide them with protection, if they are harassed in any manner in the office, that is a big issue. So, No, probably this, as far as the Chief Justice is concerned, you can't overstep. But then, when it comes to the Posh Act, also we had a recent example of a judgment by our High Court, where proceedings were initiated, criminal proceedings under the Posh Act was initiated by the Bar Council against a lawyer of repute, and ultimately the entire proceedings were quashed for the reason that the Bar Council cannot figure as employer. And same thing happened in Bombay High Court also. So the question is whether it is time for us to think, because Bar Council is a regulatory body, give an expansive definition to the meaning of employer under the Posh Act, so as to bring in the regulatory body, or come out with another legislation which should provide protection to lady lawyers especially. So these are all areas within the where the law has to change, and change it will, because of the number of representatives who are coming into the Bar Council after the present election. And when it comes to breaking the barrier, a classic example, other than Shalin, of course, is the present secretary, Nima, who fought it out on her own, along with the men, and came out victorious. So you're breaking the barriers every day. Now let us think of the obstacles, and the obstacles with confident personalities like you, bold persons like you, erudite persons like you, you'll be able to overcome the obstacles, and the court will always be there to help you. The system will be there to help you. So the present regulations that has come, I find as a first step towards that. Whatever is lacking in the regulations, that can also be looked into.
Thanks, Arun. You were talking about the competence of the lawyers, and I must, on that note, congratulate the entire research team of very, very dynamic lawyers. I had the good fortune to actually sit and interact with them yesterday. They came to my chambers just to tell me about what they were doing. And I think that turned out to be a discussion. And the kind of ideas that they come up with, and it's a whole new way of thinking. And I think it's so refreshing, it's so encouraging to see young minds actually come up with ideas which are very progressive by definition. And as you rightly said, I think we've crossed the stage of breaking barriers. Now we're really looking at what obstacles are there, or what is weighing down these efforts, or what remains to be done. I think that's the stage we need to consider ourselves in. But again, when you talk about the barriers in the profession, as I mentioned earlier, it's not only with regard to the feminist ideologies that we have data bias that informed us. Arun, you were talking about the Constitution and the lady members of the Constituent Assembly. If you actually, for anybody who has taken the trouble of reading the Constituent Assembly debates, you would find that it is not only the lady members whose contributions were largely ignored. There are a host of other people who spoke in different languages in the Constituent Assembly. And if you look at the debates, they just say that somebody spoke in Hindustani, right? And there's no translation given. One fails to understand how the others actually understood what this man was saying and what their response was. If they didn't understand, there's hardly going to be any response. But it seems to have been just brushed under the carpet. There's nothing revealing from the Constituent Assembly debates as to how those persons actually contributed. And this assumes greater meaning today, because today we have the benefit of a new book by two wonderful authors, and just as Arun recommended that book of the Mothers of the Constitution, this is another book that everybody must read. It's called Assembling the Indian Constitution. It's by two authors, Rohit Dey and Orni Shanit. It basically gives you all the material that was there before the Constituent Assembly, because we were led to believe that the Constituent Assembly debates is the be-all and end-all of all the discussions that happened leading to the framing of the Constitution? The answer is no. The reality is it wasn't just that. The Constituent, in fact, the number of days spent by the Constituent Assembly within that building holding discussions was very, very minimal. Large part of the fact gathering was done by the Constituent Assembly when they were actually moving around the country. And they received representations, they received petitions from various people, starting from marginal farmers to interest groups. And you have to read that book to really understand the reality that prevailed then. And how it's also a bit disturbing because you realize that a lot of things were just taken for granted. They were not actually given due weightage. And therefore, when you find the unrest happening in this country, in various pockets like the eastern regions, northeastern regions, you're not surprised anymore. This unrest ought to have happened a long time ago. They were largely persons whose voices were not heard then. Their grievances were not addressed or redressed after we got our independence and after we gave to ourselves this constitution. And therefore, unless you understand this background, you never really get a true idea of the problem itself. And that's what's happening. That's what data bias does. So, understanding the problems of women, when I started at the outset, what I was saying is, if you really need to understand, you need to understand what happened. You need to know the historical trajectory that this whole movement has taken. And when you have the means of understanding the other, then you can begin to solve the problems faced by them, understand the disadvantages, and then find remedies to that. When you do that, how exactly are we going to go forward? What is the move? What is the direction that we need to take? What is the trajectory that our efforts need to take? That's an area where we all need to focus. But before we do that, let's hear from Surya, because she's the one who's going to be talking to us today about reforms and practical measures. So once she gives us her thing, I would like all of you to actually just keep that in mind. Listen to what she has to say. For a fair measure, we can also chip in with our views. But more importantly, I think it is your views today that will have to be considered. Surya, over to you.
I think we all should take a moment to appreciate the momentum of this juncture that we have arrived at. In a couple of months, our Bar Council of Kerala will have women as its members for the first time in history. And we know that this change, this transformation did not come forth as a result of the society having changed. It is not a legislative victory. This change was thrust upon us. This change came in the heels of the Supreme Court directions to see that Bar Council as well as Bar Associations, a part which mostly people ignore, must have women in executive position and 30% of the executive committee members. Now, this shows that this is one way in which society changes. Sometimes it changes radically, sometimes it changes in increments, only in a marginal fashion. Now, when the society changes like this, like in a top-down way, when the change has been introduced from the top towards us, what happens is now the women and the men who will be holding power as members of the Bar Council of Kerala, they have a tall order because they have to create equality where none existed. They will have to dictate the terms in which equality will be meted to us women in this profession. And at this juncture, it is very important that we know our mind, because we cannot take up all priorities, not all at once. Therefore, as women in this profession, it is very important that we need to know where we stand, what problems do we face, and how we plan to strategize. Because different problems naturally require different approaches, different strategies, sometimes even different proponents. Now, when Ruth Bader Ginsburg took up the Women's Rights Project in 1970s, what she did was to have a list of problems and prioritize. She wanted to attack the narrowest problem, the closest question first, so that it is self-evident to the others, even the adversaries, that this problem cannot be left alone anymore. So therefore, I believe the first step after this session, this conference, should be that we should identify the exact areas of action and also a suitable method or strategy tailor-made to that problem. As I said, it could be incremental, it could be radical. And sometimes the measure that we advocate is bound to fail. For instance, a private member bill has been tabled in the Rajya Sabha by MP, Sri P. Wilson, who also happens to be a designated senior advocate before the Madras High Court, requiring a constitutional amendment to the effect that there is representation in Indian judiciary, in higher judiciary, from all marginalized or disadvantaged sections in relation to their proportion to the population. Now, we all know the fate of a private member bill. But the purpose of such a measure, such a move, such an attempt is not to win, as I said. The purpose is to push forth an idea whose time has not come, but whose time is long due. Sometimes, if the idea's time is ripe, then there will be several votaries for it. People will be competing with each other to take charge. But when the idea is long due, but its time has not yet come, then measures even that are meant to fail, even litigation battles that are meant to do, are important, because then you are putting this question as one of importance. You are requiring people to apply their mind. You are telling them that silence is no longer an answer. So I believe how much, so ever short we may feel in our attempts, this step has to be taken. We have to address difficult questions. In that manner, I would also say now recently we have introduced rules for senior designation, how the High Court will handle senior designation. What I found very heartening was there is an emphasis of mentorship. How many lawyers who have mentored before you apply for senior designation? If mentorship is something that is objectively quantifiable or measurable, then I believe mentorship of women or lawyers who come from marginalized or disadvantaged sections or underrepresented sections, that is also possible. So I believe those who make these decisions, the full court, will give due regard to not just mentorship. It is easy to mentor somebody who comes from a privileged background, somebody who comes from a privileged education, somebody who comes from a family who knows the tropes of this profession. What is difficult is to mentor somebody who did not have all these advantages. So I hope that when it comes to senior designation, this is a structural change, because we are not used to this kind of a demand being made ever from the maesters of this bar. But I believe that time has come that we make this demand. And the MC for today, Alina, she also referred to questions. She said we have to leave here with questions. I believe questions are, now the time is ripe for questions. Now, when in our profession, we are often told that our time and effort is not remunerated by our seniors, not in terms of money. We are told that our remuneration is mentorship and exposure. But then we are also told that women are unable to exploit this mentorship and exposure because we are not able to stay late, because we are unable to meet humanly or not unhealthy demands on our time. Now, where has this landed men in our profession? Look at the kind of mental health issues that plague us. Look at the kind of very deplorable number of men who have left us, succumbing to this stress. So the norm has to change. It should not be the norm that a person can only have law and law alone in her life. One must have other interests, one must be able to cultivate other interests, because I believe this is important for law also. Because often ideas are garnered not when you are buried in a law book. Ideas emerge. Law progresses when people read a book, go for a walk, or sit doing nothing. Now, we have forgotten how to sit doing nothing, especially women. We are always expected to be doing something. Now, when I was referring to questions, what I believe is when men tell us that they spend late hours at work, we have to ask them how many of those hours were actually spent at work. Do smoking breaks count? Do coffee breaks count? How much? So therefore, I believe our club, the Wednesday Club, can undertake a survey and ask these difficult questions to the firms here. What is your strategy, your policy on the well-being of your lawyers? Where do you draw the line? What have you done to enhance their work-life balance? And not in our state, but across India, across globe, we come across these awards. Best lawyer under 30 for arbitration. Best litigating firm for commercial disputes. Why don't KHCAA launch an award for the firm with best work-life balance? Let there be rewards for treating people as people, individuals as individuals, with their own set of strengths to bring to the table. Rather than everyone getting molded in one's image, let us all bring in our strengths. It will only push forth law. It will only encourage the cause of law. That is my belief. Now again, we have the image of leading lawyers and well-liked judges in several images. Some of them are famously soft-spoken, like Honorable Justice V.J. Arun. Some of them are famous for their sarcasm.
Don't even go there.
But when it comes to women who are leading us, I sometimes think that they are not variegated at all. The image that springs to our mind is somewhat plain. We do not know their different layers or shades. We do not know the sense of humor they enjoy. We do not know what other interests they have. And that is because we do not value those. We do not value those traits that make a person stand apart, not just as an individual, but also as a lawyer. I'm again tempted to go back to RBG, Ruth Bader Ginsburg. She was, while she looked very plain and serious, in one of her dissents with Anton Scalia, she used the term broccoli horrible. We should be encouraged to break these patterns of decorum and what expressions are proper, as long as it serves, conveys the meaning. So what I'm trying to suggest is every person's different strengths have something to bring, not just to themselves, but also to this profession. This profession will only get richer for that. Which is again bringing back to the point that we need to ask these questions to the firms. What have you done to let these people go, let these people explore what they're interested in? Another thing I wish to speak of. I believe when Menaka Goswami came here to argue a bail matter, she had visited the Advocates Association, the Women Lawyers Advocates Association, Women Advocates Association, and she demanded that we occupy this space, this very hall we are sitting in. If I may put a question to the audience, how many of the women here come here regularly? Well, I didn't either. But I think we should be found in these places. We should be found in these places, not just debating women's issues, not just as angry, anxious women, as people who enjoy themselves, as people who sit and read a novel. Even if you suggested, I say we not just women, men and women sit together in this room, read a book, share that experience. I believe that is something that we can readily do. If all of us sitting here today at this hour put our minds to it, this is a perception that we can easily change, that if public spaces are also for us. It is not reserved for men, although it might look otherwise. That is one thing I believe we can actually immediately do. Then another, Parvathi ma'am mentioned structured internship program, which I found was a wonderful suggestion. In fact, the SCST department of the government of Kerala has a scheme called Unnati. It provides internship to selected members from the ST community. So something like that can be considered. I am a member of the Advocate General's office, which I believe is the hugest department in itself when it comes to lawyers. So I believe those licensing can be done. Final point I would like to make, again, before I get to the final point, we were speaking of POSH and how we have recently concluded that POSH will not apply to bar associations or lawyers who employ women. When the Supreme Court came out with the Vishakha, yes, they came out with a very innovative device to fix the responsibility of sexual harassment on an employee. That is just one device. Underlying the court's leap of faith, if one may, was the recognition that women's problem is not a private dispute. Harassment or any instance of workplace discrimination is not a private dispute. It is a human right and constitutional right violation. That is why the court said we cannot now sit and watch. We have to fix the responsibility somewhere, and the court very innovatively fixed that responsibility on the employer. But that doesn't mean it is only on an employer can this responsibility fixed. If we open our minds to the idea that sexual harassment is a human right problem, it is a socio-political problem that should not affect the constitutional court, then we should very much be able to see that even without there being an employer-employee relationship, something like a POSH committee can exist, even for a bar association. Which is why there were the bar association had already resolved that a sexual harassment policy has to be in place. I believe the discussions to put that into practice is already underway. But the legal stand that right now POSH Act, the way it stands now, would not cover lawyers as employers or bar association or bar council as employer. I believe it should not thwart us in seeing that the wisdom that the Supreme Court showed in 1995 need not be limited that. All that the judgment had asked us to be is to innovate. And it is open for us to innovate, especially with talent like this. Final point I wanted to make was, I believe you spoke of visibility. This is known as narrative equity. Now, there is often a belief that when it comes to particular fields, it is men who are the experts in the matter. Now, how can we change that narrative? Now, the latest enrollment into the people who have enrolled recently into the bar, I believe many of them have taken to advertise themselves or as put forth themselves as lawyers. Now, we all know that it is important. It is important to make yourself visible. But I believe many of us do not know how to do this without affecting our ethical standards. I believe the Bar Association, our association can conduct a session on how to project yourself in areas of your comfort and your choice without violating the norms of professional conduct. That is one thing. And then there are several associations that function in this building. Some for environment, some for literature. How many women are there in leadership positions in these associations? Because sometimes what we cannot get by way of bonding with our senior in the office because we leave early. That has to be made up for by finding mentors elsewhere. Our mentor need not be just one person. We can find multiple mentors. Now, all these organizations where lawyers interact are platform for mentorship. But then again, how many women are drawn to these organizations? If not, why? How many of them have women leading them? How many have programs where women occupy the stage, the dais, not just as audience? These are all questions we can audit. Because these all questions can beget definite answers. One other idea that I might put forth. I had the occasion to speak with a number of women from the media last year, I believe, in connection with the Women's Day celebrations. and their problems were really similar. All of them, also have a profession that was dominated by men for centuries and very demanding work hours. We can always liaise with women from other industries, not just media, art, literature. We can always get ideas from each other as to how to leverage these kind of relationships. That also can be easily done. These are the points I wanted to make about narrative. Final point, concluding, I would say that we should.
I may need to step in after all.
Yes, this is for you, this line.
Then I'm definitely stepping.
Don't be afraid to forgive. Don't be afraid to forgive, but fight till every wrong is righted. So we all have problems with many of us, many of men and women who we come across in the corridors, for the way they have commented on our clothes, the way they have commented on our decorum. We all might think that they have nothing to bring to this discussion. I say be willing to forgive. We need to have as many allies we can as possible. So that is the note I would like to end.
Thank you, Surya. Ultimately, your suggestions boil down to a reimagining of the rules and regulations that must prevail in our institution. So, your point on having women representatives, if there's something that I don't really believe, it is that I don't think a problem of gender disparity or gender inequality can be solved by just having women in responsible roles. I think more important is you need to have people with the feminine perspective in that, and that can be either men or women. But I think it's important, if you're looking for a change in policy from institutions, you need to have persons with the right perspective. Because I'm not saying that women don't necessarily have that perspective, but just hark back in point of time. Some of the patriarchy is so ingrained in even women, like Parvathi pointed out. For example, I know for a fact that my mother would be aghast if my sister then said that she wanted to go out and wearing modern clothes, whereas she had absolutely no problem if I was going out. But and the person who would encourage my sister to actually go out in those modern clothes would be my father. So when you ask yourself the question, who's more patriarchal, it would be, everybody would point to my mother or my grandmother. They were born that, they grew up in that culture. So if you have somebody like that in a role which is called upon to lay down a policy, I don't think you're going to make great headway there. So you need to have people with the right kind of perspective. As for the policy changes to be effected in the firms, and also with regard to our policies with regard to senior designation, point taken. You do need a radical change in policy, but my only suggestion would be that let it not be tweaking the existing policies. Let it be a reimagining or of the whole policy thing itself. Because today, with the technical advancements that we have, I don't think we need to spend so many hours in a law office to actually get a grip of what we have to learn. A point was made by some of the youngsters who came to my chamber yesterday that we are still getting the list only by 7:30. So how do we sit in office? You don't sit in office. You have online files now, so you can actually sit and do it from home. But again, you talk about safety aspects, etc. These are things that are slowly disappearing. So I think when it comes to how a modern firm should function or a law office should function with juniors who are both male and female, let's reimagine a policy which would suit all. and which would apply equally to all. I think that would be a first step towards bridging this gender divide. Senior designations, yes. You said, how many juniors have you mentored? I don't know why that should be a policy only for senior designation. I mean, look at what was happening earlier in our courts. Like, you'd have all the seniors, irrespective of which office they had, they would all be sitting in the library here, in the old High Court library, and anybody could just walk in and ask them a doubt. The seniors would not just go back after their case was called or their case was over. They would sit in the library, and juniors would actually go. This practice was there even in the Supreme Court bar. I know for a fact that you had all the stalwarts, Farid Ariman and Soli Sorabji, all of them used to sit in those libraries, and juniors could walk in anytime and get their questions clarified. So that culture sadly disappeared, and that culture did not make a distinction between male and female lawyers. So that, I think, bringing back some of the old practices to the extent that they can still be followed is good. Visibility in shared spaces, important point made by Surya here, because I think it's necessary that you find both men and women in shared spaces. Like she said, most of you come here only for this particular program, which is supposedly peculiar to women. I started off by saying this is not a Women's Day program. This is basically a program for all lawyers. And I'm stressing on that again. No space within this High Court is to be exclusively for women, and don't clamor for such spaces. You may need special facilities to cater to biological needs, but not for anything else. So if you want to have a lady advocate's room, which you have here, let it be for those reasons and not for anything else, right? So otherwise, spaces like this, it can just be worded neutrally, like advocate's room 1, 2, 3. What's wrong with that? So, and women should have equal access. They do have equal access, but make it happen. Access those rooms. Lastly, what I want to just flag is the changes that you want to see. There are two ways about it. One is the long route, which I would say, which is because you're ultimately changing a mindset. Policy change, changes in the law, etc., require a majority to actually adopt or accept this particular perspective and then act on that to make a law. If you're going to try and change people in the legislatures and get a majority in the legislature, there's a lot of work to be done. You need to ensure that this perspective is embraced by a majority there who would then vote in favor of a law that conforms to these standards. It's a very difficult task in a pluralistic society like ours, and it will not happen in a short period of time. What then is the next best? I mean, you only have to go by the Vishaka case. I was citing that yesterday. Vishaka case, the Supreme Court steps in, lays down guidelines in 1996. The Supreme Court made it very clear that those guidelines must adhere only till such time as the legislature steps in and makes a law. That's the long route. The law came in 17 years later. Now, I don't think anybody has the patience to wait that long. In a society which you're looking for change, you don't have patience to wait for 17 years. That's almost one generation. So, that's definitely theoretically a possibility, but is it the practical way out? Is it a realistic way of realizing our constitutional goals? And there comes the aspect of, the realization of what you all are. You're all lawyers. It's a very, very powerful community. You are making a comparison with journalism. I would think that the legal community is far more empowered than the journalistic community. And why do I say that? Because you have this, instead of trying to swing a majority vote in a representative, in a legislature, which you require to change the mindsets of at least about 260, 300 people. What happens if you move a public interest litigation in the court? I'm just thinking aloud. What happens if you move a public interest litigation? You initially deal with 2 judges in the High Court, and if they are not in your favor, then you move to the Supreme Court and maybe 2 or 3 judges there, or even 5. But you're looking at changing the mindset of, a majority of 7 people. And if that can result in a judgment in your favor, then that is something, a judgment of the Supreme Court is something that the legislature cannot ignore when it then makes a policy. So there's a shorter route, and it is a route that goes through courts. And you are people who are in court. That makes you a very powerful community. And I think you should harness that power. You should capitalize on that. And since we have wonderful talent, as recognized by almost all of us here in this bar, why can't we do that? That's point number 1. Second, any change in mindset must start from the bottom, not from the top. Don't aim for the top. Start from the ground. Look at your homes. Look at your siblings. Look at your male co-workers. Let the change happen there. Try and change their mindset first. Because if you do that, you change one, each one change one. If you can just go by that methodology, then I think over a span of even a year, you would have increased your numbers to multiple levels. And this whole idea of bringing about a change in mindset, I think is important. And if you can carry that forward without anything more, I think we'll be faster to reach our intended goals. And while on that, a most important message to you is when you're talking about co-workers and shared spaces, including in this institution, the High Court, where you come daily for work, adopt a policy of zero tolerance to misogyny. It's something that each one of you can individually do. Just a frown whenever you find any of these wrong practices is enough. It's a small measure, but just showing your displeasure. If each one of you can just, because you're in this, if each one of you can just express that displeasure, it doesn't have to be very verbal or vocal or anything. Just show your displeasure. I think that will be a starting point, because you find in workspaces, if somebody is annoying you, you tell that person that, look, I find your behavior unacceptable. It's not going to encourage him. Encouragement happens when you remain silent. Because silence in our country is indeed is a pointer towards consent. That should not happen. So just respond in the best way that you can, without being very offensive, because then that has a counter effect. But just showing a policy of zero tolerance to misogyny, I think, goes a long way in bringing about gender equality. There are some questions from the audience, and let me just get around. There are about 6 questions. The first question, sadly, is addressed to me, so I'm going to skip that. Justice Arun, this one's for you. Should bar associations or bar councils take a more proactive role in prescribing and enforcing minimum standards for professional spaces, such as chambers, particularly in ensuring basic amenities like adequate toilet facilities?
Definitely, yes. The bar associations and the bar council, because their role, it is also part of their duty to ensure that adequate and happy workplaces are provided. And having said that, taking on from what Surya had said about work-life balance, and also one expression which often comes, which I got from my daughter when she all on a sudden said, "Acha, I'm on a sabbatical." Why a sabbatical? A sabbatical is an extended break from work due to pressure of work, for the purpose of rejuvenation and getting refreshed. Now, why should a lawyer, a young lawyer, be under so much pressure? And what is lacking on the part of the firm or the senior lawyer to drive a young person to that extent? That surprises me, because sabbatical is a word which at times we never heard, not in this context anyway. So that is often heard among lawyers, which should not be there. And of course,
I was just saying, fresh back from England, I told my dad this, and I said one fine morning that I'm going to take a sabbatical, a year sabbatical. So he said, it's a fantastic idea. By all means, do it, but please remember that this is not a paid one.
Now, the second is about mentoring. Of course, as Surya and Jayasankaran said, mentoring, it is welcome. It is a welcome development. But mentoring, those days, our days, we could, as was pointed out, we could rush to any senior, and he'd definitely help us the best he could. Having said that, I'll also add, see, are there among the young lawyers, this is to the young lawyers, how many of you have the right mindset to be mentored? That is an issue. You are there, because I come across a lot of cases while I was sitting. A junior lawyer comes to me and says, please, this may be passed over, my senior will come in the afternoon. The senior comes, he's just 3 months more, yes, just 3 months more practice than the junior who appeared in the morning. So the first thing is to find, of course, the seniors should be there to mentor, but the juniors should also find out the right mentor and have the mindset to be mentored. You can't be belittling your senior whenever there is some advice given, and coming out of the office and say, make a reel of what the senior has said and post it in public spaces. That can't be the attitude. So of course, in answer to the question, I'd say it is the duty of the Bar Council and the Bar Associations to provide adequate spaces, including toilets and other facilities, and ensure that it is done by the firms and the offices, because you are the regulator, you have a proactive role, and you have to put pressure and step your foot down if the offices are lacking.
Thanks, Arun. Parvathi, next question is for you. Do women, like men, have adequate opportunities to excel across all branches of law based on their capability, free from socially assigned notions of appropriate areas of practice? If not, what steps can be taken to ensure genuine equality in this regard? Further, do traditional metrics of productivity in the legal profession, such as long working hours and constant availability, act as barriers to sustainable success? And how can the system evolve to better balance efficiency with well-being? Congratulations to the person who asked this question. It's quite long.
To add to the sabbatical aspect, what Justice Arun was explaining right now, I have my junior here, Meera, who went on a sabbatical. She came and told me about 3-4 months back. She came and told me, Madam, I want to take a break. And I was not able to understand why she was asking this. I was trying to find out from her, elicit from her, like why she wanted to take this. She was very plainly, she told me, she said, I want to take a break. And then I was also slightly concerned about it. And one of the conversations with my daughter, when I told her that, my daughter immediately told me, introspect yourself, why she wants to take a break. And then I realized, perhaps, as rightly the honorable judges right now pointed out, perhaps there has been some kind of pressure from the office, from our side, that she wanted to take a break. She happily took a break, but she keeps in touch with me regularly. Still, she's here. She comes to office on and often, but then now I think she is almost like she has taken that break and then she's getting herself rejuvenated to come back. Anyways, from there to this question that has been posed to me, I think I almost touched a lot of aspects when I used my segment, when I spoke during my segment. Of course, there are notions that men alone can handle certain domains, certain expert subjects, it's only men can handle it and women cannot handle it. And of course that visibility aspect throughout it is there. For that, I had given a suggestion that the Bar Council as well as the Bar Associations can maintain, because there are so many women lawyers who have done their post-graduations and doctorates in specialized subjects. So the Bar Associations and Bar Councils can keep a list of those experts who have knowledge in those domains, and give their names, or rather extend their names to the bench also when certain areas, when they need that, as I told you earlier, when amicus have to be appointed, or when certain areas, when certain the parties before the court do not have lawyers on their own. Of course, what they do is to refer to them to the Legal Services Committee and get the panel lawyers. Other than that, the panel lawyers who have been prepared and paneled by the associations as well as the bar councils can also be used for this purpose, so that the women lawyers are able to project themselves, or rather to make themselves appear before the courts regularly. And one other aspect what I wanted to tell was regarding, there was once or twice I think there was a mentioning regarding by Honorable Justice Arun, with due respects, that there are instances where female have outshone male also. But I think the men lawyers should not be our benchmark. We do on our own. We do on our own. They are not our benchmark. And also regarding mentorship, what Surya said, I think I have a small, I don't agree with a disagreement on that. Mentoring women should not be a criteria for seniorship. Designating as a senior. Because the moment you say mentoring women will be one of the criteria, you are stamping them as vulnerable. You are trying to bring them, again it's a stamping that you are a vulnerable group. So mentoring them and then trying to bring them to a level is something which, that will give you a weightage. No. Mentoring juniors in common, like as both the judges said, mentoring in common, the junior lawyers as persons, gender neutral, that should be of course a criteria, and I think that is still a criteria. But then mentoring of women should not be a special consideration at all. And then I think somebody was, in the question, it was also regarding the listing aspect also. That is the professional time, the listing. Late listing, and as Justice Nambiar also stated, you can always, late listing and other things should not be a woman's issue. It should not be a woman's issue. It should be a general issue. Men should also find it difficult to get back home when lists are late. If you want, you can sit back at home and work. You can, almost everything is digitalized now. And once we have that hybrid form of appearance before the courts also, I think that helps women make them visible in courts completely. And also, I think two of my juniors, one other junior is also there. She's also waiting to break her fast. All three of them sit quite late along with me in the office. Most of them leave around 8:30, 9 o'clock. And I think from their home also, at least they have not informed me that from home they have got difficulties because they are sitting in the office so late. Perhaps that is a change, most welcome change. Because during my times, I had to give, I'm getting late from office was something which I had to inform. Of course, I did not take permission, I had informed. That was the difference. That is something which is being commonly seen now also. So as far as women are concerned, I think the question pattern, the question that was posed before me, as Nambiar said, was quite too long for me to comprehend the entire thing. Anyway, basically it was regarding the domains, or rather the expertise on how the women could be, whether women can also be considered equally important. As I said earlier, the structural evolution can definitely help it. Internships and in the chambers, the outlook of the chamber in the chambers, instead of that informal entry, that gatekeeping at the entry point is very difficult. Once that is structured, it will make a lot of difference. Otherwise, you get into chambers only because of your connect with the seniors, or the, as I told you earlier, senior-junior patronage or something like that. Then again, regarding the professional maintenance, how you are able to retain yourself in the profession also. counts a lot. That's again a structural change that is expected, attitude change that is expected, but not it's not at all utopian, and that too, we need not wait, as Sir Nambiar sir said, we need not wait for another 10 or 17 years for that change to come. We can have that change right away, immediately, from this place, from this shared space itself, as Surya rightly pointed out.
Thanks, Parvathi. And one last question, and that has to go to Surya. How significant is the issue of physical safety in ensuring the full and effective participation of women in the legal profession? Further, what role can colleagues play in fostering a safer and more equitable professional environment? You got 2 minutes, and after that the mic will magically stop operating.
I've seen that magic before. When questions of physical safety are raised, one, the important response to that is that it should not be tolerated. It should not be seen as one's due. But that said, I always feel that women should not be expected to fight all battles, not on all fronts. So that is where colleagues can step in. They can help women choose the way in which she deserves or chooses to address that particular aspect. Does she want to lodge a formal complaint? Does she want to address an informal method of, say, addressing the more senior members to bring the offender to task? These are important aspects where a trusted colleague can definitely provide an answer. Need not be a female, could be a man. They can always pitch in. Because I always feel it is unfair that women should, even now when we are all putting forth suggestions, we are all saying that these young women should take it up. It is not upon them, it is upon each of us. That is.
So that brings us to an end of this wonderful session. Thanks in no mean measure to Justice B.G. Arun, Parvathi and Surya for their contribution. Thanks to all of you for your patience and staying up for almost, more than 2 hours. Wow. And yes, over to you.
So today we have witnessed a deliberate, conscious and deeply desired conversation, and I thank Honorable Justice A.K. Jayasankaran Nambiar sir for setting the tone of the discussion by stating or recognizing that the status quo exists as a vehicle of patriarchal domination, and for extending this conversation to Advocate Parvathi Menon ma'am for detailing the conflict between the otherwise complementary ideas of personal resilience and structural evolution, and Honorable Justice Arun sir for reframing the discussion not as breaking barriers, but as getting over obstacles, and Advocate Surya Binoy for encouraging women, especially women in the legal field, to reclaim spaces and to recognize their own shades, layers, and their own identity. With that, I now invite Advocate Sanjana to formally deliver the vote of thanks.
Good evening, everyone. Today's discussion on breaking barriers, challenges faced by women in the legal profession, and the way forward brought into focus both the progress we have made and the responsibility that still lies ahead. As we come to the close of this session, I would like to express my sincere gratitude to all those who made it possible. I thank our moderator, Honorable Dr. Justice A.K. Jayasankaran Nambiar, for the manner in which he steered today's session, keeping the conversation both engaging and thought-provoking. I also extend our gratitude to our panelists, Honorable Justice B.J. Arun, Advocate Parvathi Menon, and Advocate Surya Binoy for their thoughtful contributions and perspectives. I would like to acknowledge the sincere efforts made by the research team in enriching today's discussion. thanking all the honorable judges present today for gracing the occasion. I would further like to thank the Kerala High Court Advocates Association and the Wednesday Club members in organizing the program and making today's discussion successful. As the very first event of the Wednesday Club, it marks the beginning of a space that we hope will continue to grow, evolve, and foster more meaningful discussions in the days ahead. Finally, I thank everyone present here today for their patient listening and active participation. Before we conclude, I would also like to take a moment to speak about the Wednesday Club, an initiative we hope will grow into a vibrant and engaging space within our community. The vision is simple: to host a major event every month, much like today's, bringing together voices, ideas, and meaningful dialogue. On other Wednesdays, we plan to curate more focused sessions, judgment analysis, and discussions, debates, and interactive exchanges that allow us to engage more deeply with the law and with each other. In that spirit, we are delighted to announce that next Wednesday, the 25th of March, we will be hosting a judgment analysis session examining the recent Supreme Court judgment on passive euthanasia in Harish Rana versus Union of India, engaging with its evolving jurisprudence and complex questions it raises. The Wednesday Club warmly invites all of you to be part of this journey. We seek not just your participation, but your ideas, your energy, and your support in shaping this into something truly meaningful. We look forward to building this together. The club is open to all, and all advocates are welcome to join. Wishing you all a pleasant evening. Thank you.